Good morning. Welcome to our 11 a.m. session. Again, a reminder to please fill out and turn in your yellow CLE certification form before you leave today. You have to turn that in to receive your CLE credits. And then a reminder about the Lunch and Learn that My Family Wizard is hosting directly after this session. It was 1998, September 18th to be exact. Justice Frank Sullivan was in his 5th year on the Indiana Supreme Court, and then law student Damon Leichty was a 3L at Indiana University Maurer School of Law. Fast forward to today. Justice Sullivan served 19 years on the Indiana Supreme Court and became a professor at the Indiana University McKinney School of Law in 2012, and now Judge Leichty took the federal bench in 2019 for his appointment. I have had the personal privilege of getting to know both of these incredible judges and people over the last few years, and it is very special to me that we are all up here today, particularly because, and I will let you do the math, last week was my 27th birthday. Thank you both for being here today. You're in for a special treat, and without further ado, Justice Sullivan and Judge Leichty.
Well, thanks, Savannah Gutierrez, for that nice introduction. It's a great pleasure to me, for me to be here this morning and to share the stage with United States District Court Judge Damon Leichty, who, as Savannah has already told you, I've known for 27 years. Many of you know that South Bend is my home. Some of you know that for almost 18 years, I had the great honor of chairing the St. Joseph Superior Court Judicial Nominating Commission, and so I've always felt a very strong tie with this legal community. Too many friends of long standing here to acknowledge, but you know how I all know who you are and know how delighted I am to see you. We're here today for a somewhat unusual topic, and I think I speak for Judge Leichty in saying we're flattered that so many of you would turn out for this. We're going to report to you on a mock court-martial of U.S. Army Colonel George Armstrong Custer for his performance, or lack thereof, at the Battle of the Little Bighorn on June 25th, 1876, where 263 troopers of the Army's 7th Cavalry died. This program was staged at the Indiana University Maurer School of Law, as Savannah told you, on September 18, 1998. Now, I might tell you that in the intervening 27 years, I've collected a lot of stuff about Custer, some of which I've brought along today, including this 1864 print from Harper's Weekly. And if you're inclined, I'd be glad to show you some of it when we're done. Our objectives here are not to give you a detailed account of the Battle of the Little Bighorn or of Custer's life, nor most assuredly to give a critique of military strategy and tactics. Rather, more modestly, to tell you about the Custer Court-Martial Project, to reflect on the ways in which the techniques of legal analysis can be helpful in understanding history, and perhaps to illustrate the way 3 civilians evaluated the performance of a military commander.
Good morning. That's pretty good, but we could do better. Good morning. Good morning. There we are. Just by way of brief introduction, I too want to thank both Justice Sullivan and Savannah for the opportunity to work with them as part of this presentation. Savannah has been tremendous in herding these 2 cats to get the presentation off the ground. And of course, it's a great privilege to rejoin with Justice Sullivan both in friendship and professionally here to give this presentation. So it's a real privilege to be here with them and also with you. Much about Custer stirs debate, and we'll try to be as objective as we can, but if you're into Custer either as a supporter or a detractor, whether you're a Custer-phile or a Custer-phobe, as it were, you will likely take issue with something that we say along the way. Custer was born in 1839, raised in Ohio and Michigan, and he was nicknamed Audie, and he was a staunch Democrat as well. Custer enrolled in West Point in 1857. His record there was somewhat checkered, and West Point itself was riven, as you all know, by the Civil War, with many Southern cadets leaving for home. As I mentioned, Custer was a Democrat, but he was a Jacksonian Democrat who could not abide the thought of breaking up the Union. He graduated in 1861, and he immediately joined the Civil War. And during the war, where he was temporarily promoted to the rank of brevet general, he had a record of both achievement and recklessness. Of great consequence to his life, there he is, brave and brash as he was. Of great consequence to his life, he married Libby Bacon in 1864. After the Civil War, Custer remained in the Army, and he was deployed in the Great Plains, and he reverted then to his regular Army rank of captain. He would eventually become, as you know, a lieutenant colonel in the 7th Cavalry, but he would never once again reclaim the rank of general. In 1867, he deserted his command in the field to travel to Fort Riley, Kansas, to be with Libby. Their relationship was notably very strong. And for this, he was court-martialed, his second one. He was convicted and then suspended from rank and command for 1 year. He only served 10 months of that sentence before General Philip Sheridan requested his reinstatement. And Custer then returned to the 7th Cavalry, where he restored the flagging morale of the unit. Fighting Indians was a really difficult task for a cavalry. Cavalry was trained for pitched battles between groups rather than a foe who would scatter and then regroup at an opportune strategic time and place. But in November 1868, Custer won a great victory over the Cheyenne at the Rashida River in Oklahoma, and at that point he had become a famous Indian fighter. From 1869 until 1873, there was essentially a truce between the Indians and the Army on the High Plains, and in 1873 there was a number of events, consequential events that began. In that year, while Custer was stationed at the Yellowstone River, there was economic panic that was gripping the country. The next year, while Custer was stationed in the Black Hills, gold was discovered. There's gold in them there hills, as they said. The government tried to buy the Black Hills from the Sioux, and when that failed, President Grant ordered the Sioux to leave. We now come to 1876, and in Washington, D.C., where Representative Heister Clymer convenes congressional hearings to investigate military corruption in the Grant administration, Custer testified about a scheme to sell Trading Post and President Grant's brother's participation in it. Obviously angered President Grant, then ordered Custer to stay in Washington, but Custer, doing what he often did, which is his own thing, he left nonetheless and returned to the Plains. At this point, Grant ordered Custer arrested, but he subsequently relented after political pressure and a direct request from Custer's commander, Brigadier General Alfred Terry.
Well, the drama now shifts to the area surrounding the Little Bighorn River, in the southeast corner of Montana, where General Terry was constructing a grand plan to bring a three-pronged attack on the Lakota Sioux Indians there. Troops would come from Fort Fetterman, Wyoming to the south, from Fort Ellis near Bozeman, Montana to the west, and Fort Lincoln near Bismarck, North Dakota to the east. Custer would be part of the attack from the east. The plan got off to an inauspicious start when General George Crook, leading the forces from the south, was attacked on June 17th, retreated without letting General Terry know, and would play no further part in the campaign. 4 days later, on June 21st, General Terry, Colonel Gibbon, who would lead the attack from the west, and Custer met on board a steamship called the Far West to plan the campaign. The next day, Terry gave Custer a written order, which was really the central piece of evidence in our court-martial. The order, a copy of which you have in your handout materials, directs Custer to proceed up the Rosebud in pursuit of the Indians. Then this crucial sentence: "It is, of course, impossible to give you any definite instruction in regard to this movement." And the order from General Terry said that even if it was not impossible, he placed in Custer too much confidence in your zeal, energy, and ability to wish to impose upon you precise orders which might hamper your action when nearly in contact with the enemy. However, in at least one respect, the order was quite specific. Custer was to thoroughly examine the upper part of Tulloch's Creek and then report to Colonel Gibbon with the results of the examination. At the same time, the lower part of this creek would be examined by a detachment from Colonel Gibbon's command. Soon thereafter, Terry says that he wants Custer to report back to him. Now, at the time of the meeting, Colonel Gibbon is reported to have said, "Now, Custer, don't be greedy, wait for us." Custer is reported to have said, "No, I will not." Custer refused Gatling guns and 4 additional companies of soldiers from the 2nd Cavalry. As the troops marched on January 23 and January 24, there were signs of Indians everywhere, and Custer followed their trail. When dawn rose on June 25th, Custer saw the biggest encampment of Indians ever assembled on the plains. He had 611 men in the 7th Cavalry. There were at least 3,000 Indians.
All right, we've now reached the Battle of the Little Bighorn, June 25, 1876. The renowned historian, Stephen Ambrose, many of you who have read and heard of him, of course, says, to study this battle is to enter quicksand. Here's what we can tell you to help you with the quicksand. The Little Bighorn River runs south to north. Custer was approaching from the east, as you heard just a moment ago, along Tulloch's Creek. The Indian encampment was on the west side of the river, north of where the creek entered. Custer's column was comprised of 12 different troops, which he split into 4 sections. 1 had the ammunition, 3 were under the command of Captain Benteen, and 3 were under the command of Major Reno, and then 5 under the command of Custer himself. Benteen goes south of the creek. He dawdles. Reno crosses the Little Bighorn and attacks the Indian village from the south. Might help if I put the map up here. He's repulsed, Major Reno, and he retreats. Custer stays east, moving up the Little Bighorn to the north end of the village. The Indian commanders, Crazy Horse and Gall, ascend the bluffs where Custer's force was assembled. The Indians attack, and Custer and his entire force, as you all know, are killed. Most of Reno's and all of Benteen's men survive. So here we are, June 25, 1876. Custer and 263 American soldiers are dead. There are no survivors among those immediately under Custer's command. So what happened? Was Custer a disobedient and reckless commander whose hubris led 13 score soldiers to their peril, to their deaths? Or was he simply a military commander whose opponents got the best of them through no particular fault of his own? These are important questions to ask because we cannot abide disobedient and reckless military commanders, nor, on the other hand, can we punish military commanders who lose battles through no fault of their own, because warfare obviously inherently involves dynamic risk.
In the now century and a half since Custer's last stand, competing narratives have grappled with the two questions that Judge Leichty just identified. And more than a few, a commonly cited statistic is that more books have been written about Custer and Custer's last stand than any other American other than Abraham Lincoln. Now, I didn't really know whether this was true or not, so I asked AI. AI hedged, but did tell me, quote, Custer is certainly among the most written about Americans. One set of narratives, often called the glory hunter genre, is highly critical of Custer. But a second set comes close to hero worship. On the hero worship side to the extreme are three books that Elizabeth Custer wrote in praise of her husband following the last stand and his death. As part of this little show and tell I brought along, I have original editions of all three of Libby Custer's books. Custer is a particular symbol for Native Americans of the white man's oppression. Here's a self-styled Indian manifesto entitled Custer Died for Your Sins. Perhaps most interesting is that this debate has continued to rage into the 21st century. I myself own Custer books with the titles of Custer's Trials, The Real Custer, The Last Stand, and A Terrible Glory, all published since our project in Bloomington in 1998, and there have been more. In an effort to lend a new perspective to the Custer debate, Professor David Williams of the Indiana University Maurer School of Law decided in 1998 to stage a court-martial. This was not an entirely original idea, as there had been both a book and a movie so titled prior to that. But Professor Williams's thought was to conduct a serious legal inquiry into Custer's conduct. For such a project, Professor Williams needed three things: charges on which to try Custer, procedures under which to try him, and participants to try and defend him.
All right, as to the charges, of which you all have copies there in your packets as well, each are predicated upon what then were called the Articles of War, the nation's military justice regime until replaced by the Uniform Code of Military Justice in 1951. The first of the charges alleges a violation of the 21st Article of War by disobedience of orders, specifically in respect of Terry's order to examine the upper part of Tulloch's Creek. Custer deliberately refused or wholly neglected to obey the order. And the 21st Article of War provides that any officer or soldier who on any pretense whatsoever disobeys any lawful command of his superior officers shall suffer death or such other punishment as a court-martial may direct. The second, here on the screen, alleges a violation of the 15th Article of War through negligent conduct as follows. 1, splitting his regiment into 4 separate groupments. 2, failing to conduct basic reconnaissance. 3, ignoring the warnings of the Indian scouts who were with him. 4, failing to provide for the security of his command. And 5, issuing incomplete and unclear orders to his subordinate commanders. And last, refusing to accept artillery and rapid-fire weapons that were assigned to him. The 15th Article of War says any officer who willfully or through neglect suffers to be spoiled or damaged any military stores belonging to the United States shall make good the loss or damage or be dismissed from service. The third alleges a violation of the 62nd Article of War, neglect of duty, in respect of the same 6 items of conduct that I just mentioned as to the other. The 62nd Article provides that all crimes not capital and all disorders and negligence which officers and soldiers may be guilty of to the prejudice of good order and military discipline are to be taken cognizance of by a general or field officer's court-martial according to the nature and degree of the offense and then punished at the discretion of the court. It was in construction of these 3 charges, we believe, that Professor Williams brought a new and fresh perspective, an approach to the Custer debate, stripped of their arcane articles of war terminology and reduced to their elements. The most important differences among the 3 charges are the respective mens rea elements. The first charge alleges intentional misconduct, the second, recklessness or gross negligence, and then the third, mere negligence. Could it be that in the 150 years since Custer's last stand, that the debate was not over Custer's culpability or lack thereof, but over the level of his culpability?
Professor Williams landed on a highly stylized procedure for our project, one not grounded in how court-martials actually operate. These are generally jury trials, but one where the advocates in the court-martial would make their closing arguments to a panel of 3 judges in the style of an appellate oral argument. We're going to show you some clips here in a minute from all of this, but the key thing to appreciate is the arguments that the advocates are making to the panel, though appearing to be an appellate oral argument, are actually the closing arguments at trial, okay? Now, to stage the proceedings, Professor Williams recruited 2 top students at the law school at the time, a student named Damon Leichty and another student named Damon Leichty. He then recruited 2 well-known alumni of the school, Kathleen Buck, a Kirkland and Ellis partner, and Robert A. Long, a Latham and Watkins partner. For the judges, in addition to himself, Professor Williams recruited me, didn't take much convincing, and for the middle chair, Justice Ruth Bader Ginsburg. As you can see, we were outfitted in 19th century U.S. Army uniforms, and a C-SPAN broadcast the program, which is still available online at no charge, easy to find. What we're going to do now is show you some of the proceeding. And you want me to run that? We're going to start with Dean Fred Amon of the law school, and delivering some welcoming remarks. Some of this will repeat some things that Judge Leichty and I just said.
Dean of the Indiana University School of Law in Bloomington. It is my pleasure to welcome you to the court-martial of Colonel George Armstrong Custer. In the spring of 1876, Custer led his command to defeat and immortality along the banks of the Little Bighorn. This afternoon, we seek to address a question of enduring fascination to Americans. What would have happened if Custer had survived and been court-martialed for his decision to attack the much larger force of Lakota and Cheyenne Indians? Beyond our particular goal of considering Custer's legal culpability, this court-martial will serve two more general ends. First, it will demonstrate superb lawyering skills. Today's arguments are the culmination of extensive research and analysis based on a detailed written record assembled by our faculty and containing excerpts from a wide variety of historians, military officers, and contemporaneous writers. The attorneys have prepared substantial written briefs, which the judges have carefully reviewed. These briefs exhibit exemplary legal analysis in writing. The arguments we are about to hear promise to demonstrate critical oral advocacy skills. Collectively, these skills are in the finest traditions of the legal profession, and they are an important part of what we seek to teach at the law school. Second, this court-martial will illustrate the importance of interdisciplinary approaches to analyzing social phenomena. At our law school, we are committed to the belief that the practice of law and scholarship about law can benefit immensely from the insights gleaned from other disciplines. Moreover, we believe that problems from other disciplines can sometimes benefit from legal treatment. The present court-martial is a very good example of such a problem. The legal culpability of George Armstrong Custer can be analyzed only with the assistance of both historians to establish historical facts and lawyers to establish the legal meaning of those facts. For decades, historians have argued over Custer's deeds and character. Their work forms the major portion of the record in this case. Now, lawyers and jurists will analyze the legal significance of that dramatic day on the Little Bighorn.
By the student Damon Leichty. There would be a small charge for making this available.
Be seated, please. This General Court-Martial was convened by Special Order 76202, Office of the Adjutant General, to hear and decide the case of the United States against Lieutenant Colonel George Armstrong Custer. We have heard testimony and entertained other evidence presented by both parties and have now reconvened to hear final arguments. Is the United States ready to proceed?
Yes, General, we are.
And is the defendant ready to proceed?
Yes, General, we are.
Then may we proceed with the final arguments, first by the government. Counselor, please proceed.
May it please the court, generals, I am Captain Damon Leichty from the Judge Advocate General's Office of the United States Army. The Judge Advocate, Lieutenant Colonel Kathleen Buck, and I represent the United States, the Department of Army, and this is the closing argument of the General Court-Martial of Lieutenant Colonel George Armstrong Custer. The War Department of Dakota preferred 3 charges against Colonel Custer. I will address the charge of disobedience of orders, while Colonel Buck will address the 2 charges of neglect of duty. If it pleases the court, the United States would reserve 2 minutes for rebuttal.
Yes, Captain Leichty, please continue.
The 21st Article of War punishes any officer who on any pretense whatsoever disobeys any lawful command of his superior officer. 3 of the elements of this charge have been established in this trial without dispute. The other 2 elements, the presence of a military order and the act of disobedience, have been established in this trial beyond a reasonable doubt. To be sure, Colonel Custer received oral and written orders. Unfortunately, he obeyed none of them. In fact, General Terry issued to Colonel Custer 3 explicit orders, extraordinarily in a written mandate dated June 22, 1876. He divided this written order into 2 parts, 2 paragraphs, in fact. The first seemingly more discretionary, the second certainly obligatory. An examination of the second paragraph indicates the presence of 2 orders, and they are, first, to scout thoroughly the upper part of Tullock's Creek, and second, to endeavor to send a scout to Colonel Gibbon with information of that examination. Several substantiated facts demonstrate that these statements constitute orders in 1876. First, examine Terry's intent. He moved the scout George Herendeen from Colonel Gibbon's column to Colonel Custer's column for the express purpose.
Captain Leichty, we have a written document before us which you have described as an order. We rely on that written document for its terms. If there is nothing that appears to us ambiguous about the character of that document, then there is no need to look beyond that document. So I ask you initially, at the very start of what you have called an order, General Terry instructs, it is of course impossible to give you any definite instructions in regard to this movement. And were it not impossible to do so, the commander places too much confidence in your zeal, energy, and ability to wish to impose upon you precise orders which might hamper your action. Now that's the preface to everything that comes after. So how can you maintain that a definite, precise instruction was violated? The only thing precise that I see is that Lieutenant Colonel Custer was trusted to use his own best judgment.
General Terry understood that this Indian encampment was a mobile enemy. And in that language that you cited, General Ginsburg, he mentions, in regard to your movement. He understood that circumstances might arise that would justify even Colonel Gibbon and Colonel Custer to alter their avenues of approach. This, however, did not give him, Colonel Custer, discretion to act or to deviate from General Terry's instructions that follow that command. And they are to proceed down the Rosebud Creek, find the Indian Trail, then proceed farther south. Those are explicit orders. He had no justification, and in this order itself, the language is sufficient reason, to deviate from that order, do reconnaissance, and therefore he did not.
As his time runs out, and he asks Justice Ginsburg for permission to complete his thought, and she gives him one sentence.
Acquire intelligence that General Terry desperately needed. If you look at the principles of war, and I see my time is run, may I finish answering your question?
If you can do it in one sentence, because you have gone over your time.
I will do that. Colonel Custer violated the principles of war because he undermined General Terry's objective, which was to approach the Indian encampment in a nutcracker maneuver by upsetting the unity of command, by thinking individually that he could whip the Indians, by preventing an attack en masse, another principle of war, as late as Thucydides, and by threatening the security not only of his own men, but also of Colonel Gibbon and General Terry's men, which resulted ultimately in the needless death of 263 men.
Thank you, Captain Leichty.
Captain Leichty, I guess I'm a little confused.
There's a practice pointer here. If you should ever find yourself in a certain federal district court in South Bend, Indiana, and be told that your time has expired, ask for one more sentence. Your motion will be granted.
I am so glad that you all signed the non-disclosure agreement when you entered this room. What happens in conference room A stays in conference room A. Are we all on the same page there? All right. Well, turnabout's fair play, right? So now we're going to observe General Sullivan, with the aid of his wit and humor, questioning Captain Azine Lotfi, a skilled student counterpart and indeed one of my fine friends from law school, on whether this written order was in fact just that, as I just told the good generals, or in fact something else.
Position. Are you saying that the written instructions given by General Terry were not in order, at least within the meaning of Article 21 of the Articles of War, or that it was in order, but that Custer had sufficient reason to deviate from it?
General Sullivan, I am putting forth to this court that the letter is not in order. That is my first contention.
It's not in order within Article 21 at all?
Correct.
And what is it then? A friendly going away present, or what? How is it that that Terry gives Custer these instructions? What are they in military law?
General Sullivan, I believe that the letter indicates no more than a mere expression of General Terry's wishes on the course of Colonel Custer's campaign. They were a practical advice to Colonel Custer to do with what he may and to follow if he deemed that it would be reasonable. However, it must be remembered by this court that from noon on June 22nd until 9 p.m. on June 24th, Colonel Custer followed the Rosebud as had been instructed in the letter. It was not until 9 p.m. on June 24th that Colonel Custer received vital information which required his deviations from the instructions that General Terry had given him. Now, what was the information before Colonel Custer at 9 p.m. on June 24th? First, he received information that indicated that the trail leading down the Rosebud veered to the west. Second, the scouts indicated that the Indians could not be located more than 30 miles away, a day's ride away from his regiment. Now, to proceed down the Rosebud at that point would have caused Colonel Custer to lose contact with the Indians, which were obviously in front of his command, to make a long detour around the Wolf Mountains, thereby placing this large obstacle between himself and the Indians.
At the end of the proceedings, Justice Ginsburg announced the judgment of the court on the disobedience of orders charge, and I addressed the recklessness and gross negligence charges. Here are some excerpts from our two speeches.
Be seated, please. We have reached a unanimous decision in this matter. Counsel for both sides have ably assisted us by presenting cogent arguments derived from enlightening evidence, and we are grateful to them. In deciding this case, we have rejected the opposing stereotypes of Colonel Custer, either as a brash, entirely reckless glory hunter, or an ill-fated, gallant, but faultless military leader. Instead, we have trained our attention exclusively on the historical record placed before us, and from that record we have reached the following unanimous conclusions. First, Colonel Custer did not violate General Terry's order because he acted within the very large discretion afforded him by that order. And second, Colonel Custer did violate the 62nd and 15th Article of War by failing to conduct appropriate reconnaissance and by dividing his force in the face of a numerically superior enemy. I will explain the reasons for our judgment regarding the disobedience charge. General Sullivan will explain our reasons regarding the neglect charges, and General Williams will offer a few observations on the reasons for this court-martial, and he will then announce the sentence. On the disobedience of orders charge, much attention has been directed to Colonel Custer's alleged state of mind and particularly his personal motives for the course he pursued. But we are convened as a court of law, not a board of biographers or psychologists. Our inquiry is therefore an objective, not a subjective one. We inquire whether Custer's actions were within the scope of the instructions he received from General Terry. To answer that question, we rely primarily on the written terms of General Terry's order. We have paid close attention to the precise words the general used. In our view, they hold the key to the proper resolution of the disobedience charge. General Terry is a lawyer, and lawyers, we are mindful, choose their words with care. We note, too, that the general took the unusual step of committing his order to writing so there can be no doubt about the words he dispatched to Custer. Our holding today is based centrally on the order's highly permissive and ambiguous language. No person skilled in the lawyer's craft, as General Terry is, would use such language to convey binding instructions, any deviation from which could lead to court-martial. The rule of lenity also dictates this result. In a criminal proceeding that involves a man's liberty and even life, we resolve ambiguities in favor of the accused.
Article 62 requires that the accused's misconduct be found to have been committed negligently. That we find Custer to have been negligent, that is, failing to perform an act required by military duty, needs little elaboration. By finding him to have breached the commander's duties, we have necessarily found him to have acted negligently. Article 15, however, requires that the accused misconduct be found to have been committed, in the words of Article 15, willfully or through neglect. As a matter of military law, the level of neglect required to be shown to sustain this charge is higher than mere negligence. While not requiring a showing of intentional misconduct, the neglect must nevertheless be of a definite and gross in this context meaning outrageous, character. We hold that Custer committed the misconduct charged willfully or through neglect. That he failed to conduct meaningful reconnaissance after being on notice of an unusually large gathering of Indians was not merely a failure to perform his military duty, it was a flagrant and outrageous failure. Similarly, to divide a regiment of 600 men into 4 units, arguably out of range of effective communication and clearly out of range to provide or receive support, these actions also constituted flagrant and outrageous failures to perform his military duty. After all, Custer had in his hands the lives of 600 American soldiers. They deserved a commander acting in conformity with basic principles of military command. Instead, almost half lost their life because their commander flagrantly and grossly disregarded those principles. Custer defends his actions on grounds that the plains had never seen an Indian encampment of this magnitude, and by invoking the principle of scattering, that when Indian villages are discovered, Indians run away, they do not stand and fight. These factors may very well explain Custer's behavior, but they most assuredly do not excuse it. To adopt such a justification for the misconduct here is tantamount to saying that a military adversary will always deploy and behave in exactly the same way in engagement after engagement. Such is not the lesson of history or common sense, and it denigrates the skill and intelligence of the Indian, who has proven to be so worthy a military adversary. Having unanimously found Custer guilty of violating the 15th and 62nd Articles of War, the question of sentence remains. To that question, General Williams will now speak.
Thank you, General.
All right, ladies and gentlemen, lastly, we want to conclude by playing for you the entirety of Professor Williams' judgment for the court-martial imposing sentence. It brings a new perspective to this whole debate of Custer, applying the skills of lawyers and jurists to a great dialogue and controversy. I think you'll find his judgment, as we both do, both profound and timeless.
Because the accused has been the object of great controversy, I speak separately to emphasize what is at issue here, and just as importantly, what is not at issue. We are not passing judgment on Custer's overall character. We don't know whether he was a good man or a bad one. Nor are we passing judgment on the morality of the Indian Wars. Custer is a soldier, and he was legally obliged to fight in this campaign, however unjust the reasons for it may or may not have been. Indeed, the charge here is not that Custer killed Indians. It is that he did not kill them well. Further, the charge is not that Custer lost, or even that he fought poorly in a general sense. Those are questions of military operations and tactics. Instead, the allegation is that Custer violated specific provisions of the Articles of War by disobeying orders, losing stores, and hurting good order and discipline. Custer might have won and still have violated those provisions, or he might have lost and not violated them. Altogether, too much writing has elided these two questions: Custer's performance as a soldier and his legal culpability. Although related, these two are distinct issues, and it is past time to insist on that distinction. Even with the issue thus narrowed, many may still object to the whole idea of court-martialing Custer. First, some Custer phobes will contend that Custer ought to be tried not for violations of the Articles of War, but for participating in an unjust campaign. In other words, he should be tried not for killing Indians poorly, but for killing them at all. Well, perhaps the campaign was unjust. Many thought so even at the time. But Custer was not the architect of this war. That responsibility lies with others higher in the chain of command and with a citizenry that countenances these wars. To focus guilt on only one individual, Custer, suggests that he is peculiarly to blame. That course is not fair to the accused, and just as important, it serves to exonerate the rest of us by making Custer the scapegoat for our collective guilt. If these wars are to be condemned, then this nation should bear the blame. Second, some Custer files will contend that it is wrong to try a brave man for actions undertaken in the heat of battle. Amidst the blood and the dust, commanders must make difficult decisions quickly and boldly, without looking over their shoulder. No one can understand the pressures present at the Little Bighorn except those who were there. And according to this view, it is therefore wrong for this panel to sit in judgment on Custer after the fact, regardless of whether we convict or acquit him. It is simply wrong to judge his actions at all. What this view fails to recognize is that all social activity is rule-governed. Without a set of norms to organize participants, no complex social behavior can ever occur. And this truth holds for war no less than for any other activity. Without unstated conventions and formal rules, no battle could ever take place. Indeed, the military as an institution is utterly committed to these ideas. Without rules, the Army does not exist. And for that matter, the Lakota and Cheyenne fight according to self-conscious rules as well, though those rules may be different from the 7th Cavalry's. In this court-martial, we have tried Custer according to those norms with which he is most familiar, the Articles of War. He is charged with failing in the soldier's fundamental duties, obedience to orders, and the maintenance of good order and discipline. Far from being an alien imposition on Custer, these rules are the compilation of wisdom left behind by older soldiers for younger soldiers. Far from being a limit on war, these rules make war possible. They bring it into being, because without rules, war cannot exist as an organized activity. Far from being a noxious straitjacket on Custer, these rules made his profession and his meteoric career possible. They are for him not a cage, but the ground of his being. A claim that Custer should not be tried according to these rules is thus a claim that he should not be accountable for his actions at all. A claim that genius makes its own rules. And so to those who say that Custer is immune from judgment because he is an artist of the battlefield, the military must respond, that is a notion appropriate to a French Impressionist painter, not the U.S. Army. Above all, the Army prizes accountability. In this court-martial, therefore, we insist only that Custer observe the ordinary rules that all American soldiers are required to observe. And it is critical that we so insist, because in any society, ultimate power belongs to those who command the means of violence. So in this country, we have always insisted that our great generals be subject to clear rules, both civil and military. And we also insist that those rules apply even in desperate conditions, because it is precisely then that military might is at its most dangerous, that humans are most prone to give way to barbarism. In trying Custer, then, we are not seeking vengeance on the man who led 263 other men to their deaths. Instead, we are affirming that even in extremis, the thing that binds us together, that makes us civilized, is our ability to live our lives according to law. It is now my unpleasant task to pronounce judgment on the accused. Lieutenant Colonel George Armstrong Custer has been found guilty of one violation of the 62nd Article of War and one violation of the 15th Article of War. We do not hold that Colonel Custer is exclusively to blame for the disaster on the Little Bighorn, but we do hold that his highly imprudent behavior contributed to that defeat and the death of his command. This country owes Colonel Custer a debt of gratitude for his past service and his many victories, especially in the cause of the Union during the recent Great Rebellion. However, this board unanimously agrees that he should not continue to command troops and that he cannot further effectively serve his country in uniform. We hereby dismiss Colonel Custer from the United States Army. All rise.
Just as a parting passing remark, that was my first and only prosecution in my life. 2 of 3 counts. 2 of 3 counts. Put aside the fact that the count I was arguing we lost, but 2 of 3 counts.
We've come to the hour that end of the hour that we were allotted. We thank you for your kind attention. Judge Leichty, I'd like to do one final thing before we conclude. Today's program would not have been possible without the organizing skills and general prodding of Savannah Gutierrez. And if she'd come forward, we'd like to give her a copy of the proceedings of our programs 27 years ago for her library, and thank her very much.
Thank you.
Thank you all for your kind attention. Damon, let's get a picture with Savannah here.